Welcome back. I expect that everybody already watched the earlier videos in this series, so I'm going to jump right into it. I will be playing the part of Delphin Delmas, representing not just the people of Santa Clara County, but by extension, all of we the people in front of the court. Imagine that I'm standing at a podium in front of the 9 justices of the Supreme Court seated at the bench. You're basically a fly on the wall on the front of the Supreme Court bench. To my right is the railroad's lead attorney, Silas Sanderson, standing at his own podium. I am going to be mashing up a bunch of quotes from Delmas, maybe adding a couple things he would have liked to have said, just to give you the essence of the case that he presented on behalf of we the people to the Supreme Court that day in 1885. The two parties to the case actually presented their arguments in 1885. The Supreme Court made its decision in the Santa Clara case the following year, 1886. Here we go. Honorable Justices of the Court, I am here today to refute the defendant's preposterous and vainglorious claim that their corporation is a person entitled to the same rights as citizens under our 14th Amendment. This goes beyond the absurd. I call it an insult to our nation's founding fathers and an abomination in the eyes of the Lord. Even a fool can comprehend the simple fact that the purpose of the 14th Amendment was to serve as a shield against injustice for all men, regardless of race or color. Finally, at long last, praise God, fulfilling the promise of a nation where all men truly are created equal, fulfilling the promise of true democracy, fulfilling the promise of liberty and justice for all. Is the defendant's claim that their corporation is the equivalent of a man a sick joke? Is it the product of minds depraved by wealth and luxury to the point of insanity? Gentlemen, these are questions that I honestly cannot answer. However, I can answer the question as to the purpose of our 14th Amendment, as can you. Its crystal clear purpose was to make man the equal of man. Black, white, brown, yellow, all equal in the eyes of the law, as they are in the eyes of God. Not to make corporations the equal of men. Corporations are the mere creations of men, created to serve a profit-making purpose. Men are the creations of the divine, created to serve a higher purpose. And the profane, in my eyes, and in the eyes of any being possessing a soul, the profane notion that man-made, bodiless, soulless corporations are the equal of God's children is an immoral, and I would dare say, blasphemous proposition. Thank you. Kinda needless to say, the Supreme Court in the Santa Clara case did not rule that corporations have the same rights under our Constitution as American citizens, as God's children. What is bizarre is that in a nation that is supposed to be governed by rule of law, no law ever passed by our United States Congress, and no interpretation of law by any Supreme Court in our nation's history ever did that. But it happened anyway, as the result of something a court reporter did. To understand how that happened, you first need to understand a little about how the Supreme Court works. Every year, thousands of cases are appealed to the Supreme Court, but the court looks at the documents submitted by both sides, and in the vast majority of cases, they decide that the lower court's ruling was correct. So they decline to hear the case, allowing the lower court's ruling to stand. If there was something iffy, a technicality, which there was in the Santa Clara case, Then the Supreme Court will decide to hear the case. They'll set a date for what are called oral arguments. That's when both sides show up and argue their case, as I just kind of acted out with Delphin Delmas arguing part of their side's case. The entire time both sides are arguing their side of the case, a court reporter is noting down everything that is said by everybody. In the 1880s, before fancy gadgets were invented, the court reporter would note down everything said by everybody in a kind of code called shorthand, so that he could write fast enough to keep up and make sure that he was keeping an accurate record of everything everybody was saying. When the oral arguments were finished, then that court reporter would write out everything that was said longhand into a nice, neat document called a transcript. At that point, lower level clerks would write out, or in the 1880s, maybe type out that transcript into copies for all of the justices, who would also get copies of all the documents submitted by both sides so that they could start working on making a decision. An important thing to remember is that once the court reporter has completed that transcript, his work on that case is, for all intents and purposes, done. He or a different court reporter would have to show up when the court's final ruling was handed down, but that was more or less just a formality, as I'll get to in a minute. I should also mention that court reporters in those days were always males. Sorry ladies, but as I pointed out last video, you were not even people yet. Anyway, the point is, during the Santa Clara case, the court reporter was a man by the name of J.C. Bancroft Davis. So you know the J.C. at the beginning of his name does not stand for Jesus Christ, although it might as well, because he, more than anybody else, was the person responsible for granting corporations the same rights under our Constitution as God's children, born as citizens in the United States of America. Back to how the Supreme Court works. Once the justices have the transcripts of the arguments and all the other documents, they would individually, then as today, research all the technical and constitutional issues until 5 or more of the 9 justices agree on the outcome of that case. At that point, one of those justices in the majority would write out what's called a majority opinion, which is the decision of the court in that case. Once those justices in that majority agree on the wording of that majority opinion, that case is, for all intents and purposes, over with. Done. The fat lady has sung, Elvis has left the building. At that point, the chief clerk of the Supreme Court would notify both sides that the court would be handing down its decision on a particular day and time, and have lower level clerks prepare copies of that decision for both sides, for the court archives, and very importantly, a copy for the publisher of the official record of the United States Supreme Court, to be published in one of those big fat law books that you see in law libraries, attorneys' offices, and judges' chambers. This is going to be really important in a minute. On May 10th, 1886, Delmas and Sanderson were at the Supreme Court in Washington to hear the court's decision. Keep in mind that the decision had been written maybe weeks, possibly a month or more, but back then it would take time for those guys to arrive in Washington from California. The decision was actually in favor of the railroad because Sanderson had cleverly identified a technicality having to do with taxation on the fencing. But the Supreme Court did not rule on any of the other issues that Sanderson raised, including the 14th Amendment issue. Keep that in mind because it's important. Ordinarily, whenever the Supreme Court would hand down a decision, As soon as there was order in the court, the Chief Justice, in this case, Morrison Remick Waite, would have the Associate Justice who wrote the decision, in this case John Harlan, read it out loud to the court. And that was pretty much it. Court adjourned, everybody could go home. This was not an ordinary day at the Supreme Court. That's because literally seconds before having Justice Harlan read the decision, Chief Justice Waite made a bizarre, out of place, actually nonsensical comment to the court, dutifully noted down by his court reporter, J.C. Bancroft Davis. Keeping in mind that the oral arguments part of the case had been concluded the previous year, and the decision itself had already been written probably several weeks, maybe months before, you can decide for yourself whether or not it made any sense at all for Chief Justice Morrison Waite to say, essentially, we don't want to hear any argument on the question of whether the 14th Amendment applies to corporations. We are of the opinion that it does. Then, as he would normally do, he had the Associate Justice, Harlan in this case, read the actual decision. Then the case was completely over with. Done. The court clerk would have filed all the paperwork away in the court archives and, importantly, sent a copy to the publisher of the official record of the U.S. Supreme Court, which at the time was a company called Banks and Brothers Publishers in New York. This is where the story gets more interesting and a little more complicated. That's because a publisher of court case law books, like Banks and Brothers, needs to have a skilled writer with good knowledge of the law working for the company. That's because for every case going into the books, the publisher needs to have that writer write an accurate, concise, few-sentence summary of what the case was all about in his own words. Then the writer would have to write an accurate, concise, several paragraph summary of the court's ruling in his own words. Together, that summary section that's published in the law books is called the headnote section. It's really important because whenever lawyers or judges are looking through those books, looking for a similar case, that's what they read. Well, the legal writer working for Banks and Brothers Publishers in New York at the time was essentially a freelancer, living and working in Washington, D.C., with a day job at the Supreme Court. His name? J.C. Bancroft Davis. Because this video is going to run way too long if I continue, I'm going to leave off with that as a cliffhanger and pick up the story there next time. See you then. If you like this video, why not click the like button? I'll put a link to the next episode over here.